So Mr. Jude, my neighbor, na landlord wey don build the house. Only 3 months ago, he put Mr. Jegede inside that house wey him build. Information reaching me just now be say last night nobody fit sleep for the compound because of too much noise and quarrel between Mr. Jude and Mr. Jegede. Then just the quarrel, they shout up and down, "Oga, you have breached the terms of the tenancy." So today, we will talk about terms of tenancy. When you go into a tenancy arrangement, one of the most important things to do is to take note of the terms of the tenancy. Why is it important to take note of the terms of the tenancy? This is because the terms of the tenancy spell out the duties and responsibilities of the parties to the tenancy, who in this case are the landlord and the tenants. If either of the party fail to carry out the responsibility placed on them by the tenancy agreement, that amounts to a breach. And as we know in law, where there is a breach, the law would always provide for a remedy. What can you do when the terms of a tenancy agreement are breached? There are several options available, but we'll look at just 9 of them. Number 1 is to review the tenancy agreement. Start by thoroughly reviewing the tenancy agreement. The terms and conditions in the tenancy agreement will dictate the rights and responsibilities of both the tenant and the landlord. Ensure that the breach you are complaining about is clearly defined and stated in the tenancy agreement. Number 2 is to communicate. When you believe there has been a breach, you have to communicate with the other party in writing, clearly outlining the nature of the breach while making reference to relevant clauses in the tenancy agreement, and at the same time, request a remedy or corrective action within a reasonable time frame. Number 3, document everything. Maintain detailed records of all communication and incidents relating to the breach in question. This documentation can be invaluable when litigation becomes necessary. Number 4, mitigate damages. Both landlord and tenant have a responsibility to mitigate damages. This means taking reasonable steps to minimize and reduce the losses. For example, a landlord can take reasonable steps to re-rent the property to another tenant, where the tenant has breached the tenancy and as a result vacated the premises. And a tenant should also do well to find a replacement within time if he has to move out early. Number 5 is eviction. This is a remedy available only to the landlord. If the breach is significant and is not resolved through communication, the landlord may need to initiate eviction proceedings, following the legal process prescribed by the law. This typically involves issuing relevant notices to the tenant and then following through with eviction processes before a court of law when necessary. Number 6, tenant remedies. Where the landlord has breached the tenancy agreement, let's say for example, failing to make necessary repairs to the premises or the property, the tenant may have remedies which include number 1, withholding rent. Number 2, repairing and deducting the cost of repair from rent. Or number 3, terminating the lease with proper notice to the landlord as prescribed by the local laws. Number 7, mediation and arbitration. It is always necessary to consider other dispute resolution options or alternatives such as mediation, arbitration, negotiation, or even conciliation. But this can only happen where both parties are willing to submit themselves to it for peaceful settlement. These processes can be less time consuming and in some instances even more expensive, but though timely, than going to court. Now, number 8 is legal action in court. If a resolution cannot be reached through communication, mediation, arbitration, or any other dispute resolution mechanism, parties will be left with no other option than to go before a court of law to resolve their dispute one way or the other. And if you are taking this step, it is important that you consult with a lawyer to advise you on the best course of action to take to seek redress. The last option to consider in event of a breach is to seek legal counsel. When in doubt or facing complex legal issues, it is advisable to consult with an experienced legal practitioner who has relevant expertise in real estate and tenancy. They can provide personalized guidance and represent your interests in legal proceedings. So what are you waiting for? Call a lawyer today.